So here is the link to the motion. Let me pull it up and get a giant screen and we'll read it. It's a renewed motion for fair and constitutional trial. So this will be good. This will be good. I do still have the law and crime feed open. I'm sure it's going to end. I don't think they'll interrupt, but just in case. But we got this in today at 4:06 p.m. That might be why he ran out of the room. So let's see, you guys. And don't forget, if you're heading out now because you just wanted to watch the evidentiary hearing, don't forget that there is going to be a panel show tonight on Nick Staro's channel. Kayla's going to be there. I'm going to be there. Infamous Sylvia is going to be there. There's a bunch of names on that panel. So it'll be a good time. And I got to make my screen smaller because I can't see the document on my own screen. Let me make this bigger. There we go. So comes now Mr. Shannon Stillwell by and through undersigned counsel and hereby files this renewed motion for fair and constitutional trial in the above styled case. In support of this motion, Mr. Stillwell shows as follows. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and, this is the word that beats me up, you guys. I say substantive, but it's substantive, as U.S. English. Substantive felonies. Mr. Stillwell is an innocent man. Like all citizens, Mr. Stillwell is guaranteed a fair trial and due process by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. The 6th and 14th Amendments of the United States Constitution guarantee criminal defendants the right to a fair trial in front of a fair and impartial judge. That's Poole v. State. The Due Process Clause guarantees a defendant a trial free of prosecutorial misconduct. Whitmore v. State. Mr. Stillwell and his co-defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of this trial. Judge Earl Glanville was the original trial judge in this case. Judge Glanville was recused from this case via an order signed by the Honorable Judge Krause on July 15, 2024. Mr. Stillwell's rights. The state is seeking a life without parole sentence for Mr. Stillwell if he is wrongly convicted. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. Prosecutorial misconduct implicates a criminal defendant's due process rights when it renders a trial unfair and violates the defendant's right to a fair trial. Whitmore v. State, 2005. Due process also requires that Mr. Stillwell receive a fair trial in front of a fair tribunal. That's Poole v. State, Serdula v. State. Judicial integrity is a state interest of the highest order because the power and prerogative of a court is to resolve disputes, rest upon the respect accorded by citizens to a court's judgments, which in turn depend on the issuing court's absolute probity. And that's Mayor and Alderman of Savannah versus Batson and Cook. To the extent this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that this court take appropriate actions. While Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge, this does not cure, this is important, this does not cure the constitutional errors and the resulting harm to Mr. Stillwell, which has already occurred. Readily apparent examples of error, impropriety, prosecutorial misconduct, and judicial partiality. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. As detailed in depth in co-defendant Williams' July 10th motion for a fair trial, the prosecutors of this case have repeatedly failed to follow the orders of the court, have made specious allegations against defense counsel, and have lacked candor to the court. Hey, we have that on the record. We have Judge Whitaker acknowledging as much. So, this case, we got a little reference there. This case has been plagued by improper rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801D2E. Defense counsel has routinely been cut off by the prior trial judge when arguing these matters, and rulings have been made with little or no analysis. This case has also been exceptional in the mistreatment, that's in the transcript, in the document, of defendants and defense counsel. Examples include, but are not limited to, A. An incident which occurred on or about October 2nd, 2023, when Judge Glanville initiated a contempt hearing against undersigned counsel, Max Schardt, attorney for Mr. Stillwell. Footnote here says that counsel is solely concerned with his client, Mr. Stillwell, and not himself. Nonetheless, the treatment of defense counsel in this case is evidence of Judge Glanville's lack of impartiality throughout this case. which violates Mr. Stillwell's constitutional rights. On this date, Judge Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him some bullshit. We have a footnote here in open court. So this footnote says, as defense counsel never uttered these words, undersigned counsel is relying on his memory as to what specifically the specific alleged uttered words were. The press was not filming that day, and the transcript was not available to counsel at this time. While in chambers, undersigned counsel was advised that he should not deny the accusations, as it was all captured on video. Footnote 3 says, obviously, this was not an effective interrogation technique, as undersigned counsel knew that he did not commit said act and would not be shown on courtroom video doing so. When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in the day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. Footnote 4 says, the reality is that the court was demanding that undersigned counsel lie to the tribunal by falsely confessing to something he did not do. Okay. Tell him, Stu. Schardt. In the end, the attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that, quote, captured the event was never produced and no apology was made. B. Judge Glanville has repeatedly demanded that certain defense counsels, including but not limited to undersigned counsel, attorney Brian Steele, and attorney Carrington Matthews, to sit down in a terse and abrupt manner when overruling valid objections, all in front of the jury. These incidents have been too numerous to document individually. C. Judge Glanville has sustained specious and frivolous vagueness and facts not in evidence arguments from the state that has effectively cut off the defense's ability to conduct a thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel's attempts to effectively cross-examine Investigator Tyrone Dennis. So Investigator Dennis. D. Judge Glanville, on 2 different occasions, baselessly called attorney Brian Steele unprofessional and unprepared in front of the sitting jury. When it was shown that Judge Glanville's comments were completely off base, Judge Glanville refused the defense request to issue an instruction that the jurors should disregard his comments about attorney Steele. Judge Glanville has monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse, and we heard this. Glanville made a judicial record of this when he talked about Kayla Bumpus in the hallway. Monitoring, tracking, we see that tracking language used in the June 7th transcript. If you haven't seen that, we did a read-through of it. I clipped it, and it's separate on a video in the channel. But this point E, Judge Glanville has monitored. He stated this in that transcript. He's monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse through security cameras for no permissible purpose and without cause. F. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis and has repeatedly misstated the law covering reciprocal discovery. Something that we saw Judge Whitaker kind of schooled the defense on Wednesday. I think it was Wednesday. All to obtain an unfair advantage from Judge Glanville. Judig Glanville, we have a typo there. The state has gone so far as to contact non-attorney members of the defense team and demand that they provide certain items to the state, without consulting defense counsel first. These actions were taken without any legal basis and were an attempt to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. Yeah. The state intentionally and erroneously accused Attorney Steele of tampering with and altering jail calls made by Kenneth Copeland, which were served in reciprocal discovery. Of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. On June 10th, 2024, this is a separate point. On June 10th, Judge Glanville held an illegal contempt hearing against attorney Brian Steele. Judge Glanville briefly incarcerated Mr. Steele and attempted to sentence him to 20 days in jail. Judge Glanville deprived attorney Steele of due process and the assistance of counsel. The defense, after repeated requests, has finally been provided with the state's June 7th, 2024, here we go, ex parte motion for order to compel testimony necessary to the public interest. This motion submitted by elected District Attorney Fonnie Willis and Chief Deputy District Attorney Adrian Love, contains, upon information and belief, a glaring misrepresentation. In paragraph 11 of this motion, so if we get to see this, we're going to look at paragraph 11. Is it attached? We'll see. The state asserts that after an encounter with the defense team members, Copeland informed representatives of the district attorney's office that he may attempt to plead the fifth in order to avoid testifying against members of YSL. The motion does not provide any information regarding the specifics of this alleged encounter or which defense team members were allegedly involved. But we hear in that meeting, we're tracking in the courtroom. Something seems off about Melnick, about Caleb Bumpus. Think about that, you guys. This is what Fonnie and Love tried to put in their order for this immunity. This is their reasoning. We've been saying we want to see it. Schardt saw it, has a problem with it. Upon information and belief, after reaching out to defense counsels involved in this case, that information is completely false. Upon information and belief, no members of any defense team had any contact with Kenneth Copeland on or about June 6, 2024, so the Thursday. It goes without saying, upon information and belief, no defense counsel or members of any defense team ever interacted with Kenneth Copeland in any way that would dissuade him from testifying. This false and disparaging information about defense counsel was provided to Judge Glanville in an ex parte motion. So the defense only just got to hear about or look at this motion and hear about what's being alleged was in that motion this week, because it was filed ex parte. The June 10th ex parte meeting. And we're going to cite the same thing we've seen a lot. Except as authorized by law or by rule, judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. That's Rule 4.1. Ex parte hearings are only authorized in the case of extraordinary matters, such as restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of any objection that may be properly registered. So City of Pendergrass v. Skelton, citing to Anderson v. Fulton National Bank, ex parte communications are presumed to have been in error. Additionally, the Georgia Code of Judicial Conduct Rule 2.9 instructs judges to generally avert ex parte communications to assure fair hearings. Rule 2.9 generally permits ex parte communications, subject to a narrow exception, for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that A, the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and B, the judge makes provisions promptly to notify all other parties of the substance of the ex parte communication, and gives the parties an opportunity to respond. On June 10, 2024, while the defendants and defense attorneys were all in the trial courtroom, waiting for trial to start, Judge Glanville, Love, and or Fulton County Deputy District Attorney Simone Hilton, as well as witness Kenneth Copeland and his attorney Caleb Bumpus, all met ex parte. Upon information and belief, this ex parte meeting was initiated by Love. Neither Copeland nor his attorney requested this meeting. In fact, neither Copeland nor Bumpus ever expressed any concerns which would have prompted anyone to consider such a meeting at all appropriate. When the state falsely characterizes this meeting as merely a discussion about Copeland's grant of immunity, the reality is that Copeland had already been granted derivative use immunity on June 7, 2024. There was nothing else for the parties to discuss regarding the grant of immunity. Copeland never requested to meet with the prosecutors and the trial judge to discuss these matters. Additionally, the ex parte communications were about more than Copeland's previously granted immunity. Judge Glanville and the prosecutors discussed Copeland's proposed testimony and provided legal advice, albeit incorrect legal advice, and strategy to Copeland. Throughout this process, Judge Glanville was clearly working in concert with the state and abandoned any semblance of impartiality. Neither Judge Glanville nor the state revealed that these ex parte communications had occurred to the defendants or defense counsel, who were waiting for hours in the courtroom, completely oblivious to what was occurring behind closed doors. Judge Glanville's silence violated Georgia Code of Judicial Conduct 2.9A1B. The defense would likely not know of these communications and their substance if not for attorney Brian Steele, who learned of the meeting by happenstance and confronted the court, bringing sunlight to darkness. When Attorney Brian Steele inquired about the secret June 10th meeting, Judge Glanville immediately sought to hold Attorney Brian Steele in contempt of court. And that's kind of why so many eyes got on this case, you guys. Judge Glanville attempted to incarcerate Attorney Steele for 20 days for refusing to reveal how he learned about these illegal ex parte communications. Judge Glanville had deputies take Attorney Steele into custody and attempted to incarcerate Attorney Steele without notice or legal counsel. As the existence of the ex parte meeting became known, Judge Glanville frustrated undersigned counsel's attempts to learn more about this meeting, including undersigned counsel's repeated requests for a transcript. Judge Glanville claimed that what occurred in the secret meeting in his chambers was privileged. This claim of privilege was without merit. Judge Glanville, it appears, instigated some sort of investigation into this incident. The focus of this investigation was not on the impropriety of the illegal meeting, but rather on how Attorney Steele and other members of the defense learned about it. This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements. Tracking. He said in the transcript on June 7th, "I'm tracking. I've been tracking since the beginning." This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements of Attorney Steele and undersigned counsel. Law enforcement is an arm of the state, of the prosecution. This is an example when you think of how the bodies are supposed to be distinct. This is the tribunal acting with the state. This is the court acting with the state if they're using law enforcement resources to look at this on their own accord. To track the movements of Attorney Steele and undersigned counsel through the courthouse. And remember, Glanville put that on the record himself. He's saying that the deputy brought it to his attention. But he said in the June 7th hearing, "I'm tracking." As public pressure mounted, a transcript of the meeting was eventually provided to the defense. The transcript of the meeting speaks for itself and is shocking. The transcript reveals that A, neither Love, Hilton, or Glanville had a legitimate basis to engage in ex parte communications. B, the ex parte meeting was not requested by Copeland or his attorney. C, the prosecutors, specifically Love, misrepresented facts and made specious allegations against Attorney John Melnick, undersigned counsel, and Attorney Steele to Judge Glanville. The details of these misrepresentations are discussed more fully in motions filed by Attorneys Schardt, Steele, and Weinstein, and motions filed on July 23rd. The prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use immunity and applicable statute of limitations. Footnote says that the state claimed, and Judge Glanville ratified, that Copeland faces no legal jeopardy in this case by advising Copeland that the statute of limitations has run. It is unclear how the state and the trial judge came to this conclusion. First, this conclusion ignores the tolling provisions of the statute of limitations in Georgia. This is like counting time. Second, even for older incidents, their legal analysis interesting in light of the case. Their legal analysis is interesting. It's probably a typo. Their legal analysis is interesting in light of the case that they are currently prosecuting and would be interesting to the 6 defendants at trial. Those individuals who have entered pleas to this indictment and those who continue to languish in jail waiting trial for this indictment, as they are charged under a RICO count that includes cases dating back to January 25th, 2013. So we got to go back up. So basically, we were at this paragraph here where the prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use of immunity and applicable statute of limitations, all in an attempt to coerce Copeland to testify. That's their purpose. Am I boomerang? Oh, I'm sorry. We're here. Did they make a new live feed? I'm going. Of course they're back. It's because it's a new feed, you guys. There we go.
Converse, and if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay, thank you.
1.25 okay with you guys?
All right, see y'all at 8:45 on Monday, 9 on Monday. Yes, Mr. Schardt? let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to sleep. 9 o'clock on Monday. Yes, sir.
Your Honor, I just wanted to bring it to the court's attention that I know that Mr. Weinstein has an outstanding motion that
This is
he
the
renewed,
beginning. This is all the way at the beginning,
maybe
you guys.
48 hours ago.
Which was,
You might confirm about Mistrial?
Yes.
oh, no, I know. He has a supplement to that. And I thought I said this morning, that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
As
have
we
more
head
to
into
add?
Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
he is.
It's very kind of you.
Welcome.
So I recently filed while we were in court,
Oh.
a motion, for a fair trial seeking remedies. Oh, and I will email, it was just filed. And I will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
On which matters?
the ex parte communications and the impropriety.
Yeah,
or-
like wanting to cross-examine the, oh, yes,
Calling
wanting
John
to
Melnick.
put Mr. Melnick's testimony. And yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
Y'all don't want to do just a proffer.
Mr. Steele was the, spoke to Mr. Melnick, but, yeah.
Okay, all right. So with regard to the motion, Mr. Schardt, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said, talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what your Honorable Court said. He stated that it was very nice. He said that I does not give you permission for him. He'd like to address the court himself. I said, okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told
Okay.
you. I was gonna
What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say, here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused? And maybe y'all want me to, I have not finished reading all of the material and all of the case law. So I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So under CAR, C-A-R-R versus state, it's a 19, I think, I don't know, 97 case, 98. It was the case that gentleman owned Heights Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to, they carry the burden of, they can charge people, they could ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not accurate.
Okay.
And I think that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, and I'm not picking on anybody, but like the Honorable Judge Krause said, if if I was going to ask this honorable court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretense.
Okay.
Mr. Melnick is going to say that what Adrian Love said to the judge is just patently not true. Via emails, her description of the emails is untrue. And there's no way to say that's inadvertent because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's.
All right, the best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody give me the emails.
I did. I put it in my motion that I filed when I found out this honorable court was the court. And I forget what I titled, I can find out for you, but.
Okay, I'll go back and look at those.
It was a motion, it had two parts to it. And it said, I really don't want, and I told you, I don't want a mistrial. I just want to make it right. And I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you'd make a credibility determination. Adrian Love, John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript. So Mr. Weaver is either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean, you are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Ms. Bumpus talked privately, which obviously nobody recorded because the court, at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Miss Hilton, or I think Miss Hilton, Miss Bumpus, and Mr. Copeland could talk together.
This has to be a mistrial.
Not privilege.
Okay,
He told
all
her
right.
that there was substantive conversation about the.
Look at her
killing
ear. What is she doing with
of
her
Mr.
ear?
Copeland.
Okay, so
And Ms. Hilton,
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
impeachment.
Okay, impeachment, okay,
Which is.
and therefore Brady. Okay,
So that's why I wanted to put.
all right, thank you.
And call the prosecutors. Now, they may say that didn't happen, and I assume that's what they're going to say because they would have a Brady obligation to run out and say, June, this happened, this man said this, but they didn't say that with anything. So I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady? Because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that,
I
so.
got it now, but I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? by Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right. And that's why I asked you to have an evidentiary hearing.
Okay.
But I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged, that Ms. Bumpus, Ms. Hilton, Mr. Copeland spoke, and it's not in the transcript, and Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved.
Mm-hmm.
He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th, and I did not get that from Ms. Hilton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to call the witnesses because,
All right, well, you didn't tell me that before.
okay, well, I didn't mean not to tell you that, but I'm not trying to be open, but that's the reason I wanted to call witnesses.
Okay, I mean, that's, okay.
Additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte
Oh,
communications.
I know, that's a
And-
part of Mr.
Right.
Weinstein's motion for mistrial, yeah.
And, you know, I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns, but Mr. Melnick can explain, you know, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
And I think that's important for the court to know.
Okay, well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to
Yeah,
you.
and they said they didn't think that Woody was in
and by
fear.
the way, y'all, I know that everybody, whenever we were here last,
Come on.
was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte because people from the defense say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's
Barely.
not quite the
We had to replay it to hear
salacious
it.
revelation that y'all made it out to be.
Can I respond to that?
Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for the for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair reasonable deduction would be that they were going back there to present the basis for granting
Okay.
immunity. Little did we know that they had already done that and they were going back there to have that other
Something else.
conversation. So
Okay.
that's
Okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that
Well, how did they
occurred
get?
as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No,
Okay,
so we submitted a motion.
right. And they have a copy of that, and that's,
Right.
all right,
Right.
Okay.
That was,
okay.
and Judge, I also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I
Well,
think.
you could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay, well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right, well, Mr. Schardt, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but, okay.
And Your Honor, so that we are, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for,
Maybe,
would that be a collateral issue of?
maybe.
Okay. So,
So if I end up hearing from the two of you on that, I'm not gonna make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
okay, and so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday. All right,
One last thing, Your Honor. On Tuesday, I believe I brought to the court's attention whether or not the court would allow, if we get to Mr. Copeland next week, I know you said the jurors might not come back until Wednesday.
right.
Substitution of counsel, and
Uh-huh.
wanted to see if the court had made a decision or a ruling.
Oh,
There's one
so-
objection.
Yeah, I
Who
never
was
got any
questioning
kind of
Copeland?
written anything or further objection from anybody. So I think there's just the one objection that I didn't get a real good reason for. Okay, yes, there may be a substitution
Thank you.
if we end up examining him while you were gone. Thank you, Mr. Weinstein. All right, we're actually in recess now.
Are we? Are we for sure? Guys, oh my God. So Melnick wants to call Love a liar. Steele says that on June 10th, in that June 10th meeting in Chambers, whether it was captured on the record or not, in the presence of somebody else, because he said it was not attorney-client privilege. Someone else had to be in that room while this was happening. Woody said, Kenneth Copeland said, he killed Nut, Donovan Thomas. Shout out to the lawyer you know.
What's up, everybody?
What's up, everybody?
We have some
We'll go
answers.
over. Shout out to the lawyer you know. I hang out over there sometimes, a lot of the time actually. Well, technically, I did log out. The Law and Crime stream had ended, you guys. That was a new feed. They had to create a whole new feed to go back live on the record for that. And thanks to the chat for blowing me up for like, what, that was like 11 minutes. You guys were like, they're back, they're back. I'm just over here reading this motion, stopped on letter E. I'm going to clip this motion reading too. I might leave the 15-minute Law and Crime, 30-minute Law and Crime clip in there too in the middle so you guys can see me, boomer. But yeah, I wouldn't have known without you guys. Like, this is crazy stuff. Yeah, totally love Big George, the lawyer you know's dad. So the lawyer you know brings his dad on once in a while. They're both in law. And Big George used to be a prosecutor, I think, right? For many years. And now they have their private practice. And really insightful. And they don't always see eye to eye. So they get to disagree in a very, like, mature, loving, insightful way. Really, really cool. Yeah, I guys, come on. If Deputy Brown was in there, it could be coming from Deputy Brown. So Kayla Bumpus did say she's not exactly sure about certain things that were said when nobody else was in the room or somebody was in there or what would have been on the record or not. She said she would have to double check. And again, if she's the one that would have been in the room the whole time, out of anybody, she would be the one that might not be the most sure about who was there at a certain time when someone was trying to talk to her. Because there's a lot going on. There's a lot of movement. So she did qualify that, you know, she thinks they were complete because there may have been other things that might not have been recorded. And then let's see. Thank you so much earlier, Jose Guzman. Great streams today. I mean, technically it is great streams now. We've had 2 long crime streams on here because they had to cut back up. Miss AB says these lawyers are earning their fees, especially after that. And then she's like, get the heck out of my court. She almost tried, was that about like 3:45-ish? She thought they were going to be done. It looked like she was ready to wrap up. And then Love said she had one more thing to address. And then something while they were dealing with the headphones, trying out the headphones, somehow we get back on the record. Maybe Schardt mentioned that motion was filed or whatever. Thank God Law and Crime, the media pool, didn't rush out of the courtroom. And then also, take all my money. I'm the non-lawyer earning my fee, Miss AB. I appreciate you so much. And what do you guys think? What do you guys think about Judge Whitaker's reasoning that because Love said we want to have an ex parte, that kind of makes it okay? Because the standard is the state is supposed to provide their basis for requesting an ex parte and why it should be ex parte. So is it sufficient for someone to just say we're requesting an ex parte and then not state your reason while you're making that request? Because that reason isn't on the record in that moment when Whitaker is asking for them to have objected at that moment in time. So them hearing it is a problem, right? Did they actually hear it? But 2, shouldn't they have put their reason on the record? Why would the judge have allowed that at all without a reason being given? So I don't know. And then, you know, the whole prompt disclosure issue just stacks onto that. Thank you so much, you guys, for like saying it over and over that they were live again. We could finish out this motion. I do want to scroll and peek. We are on page 10. Is there an exhibit? Okay, so this looks like all motion. So he didn't attach the actual motion that was drafted and eventually signed to get this immunity in place. So I don't see that as an exhibit. So I'm still interested in what that says. But we did see a little bit of hinting from Schardt about what was in that motion for the immunity order. And yeah, Monday's going to be wild. By the way, you guys, on Monday, I will have to do 2 halves. I will break at noon Eastern time, which is usually when they're doing their lunch, and come back. So we'll do a morning and afternoon type of stream on Monday. Because I have a meeting that I booked for Monday about this. The same thing I talked about earlier in the stream. These DNS records that aren't properly set up, and they're sending a business's email to spam every time they're trying to contact clients. Not good. Definitely an emergency issue. So we're going to sort that out between morning and afternoon sessions on Monday. I think that'll be good too, because it'll make the sessions more digestible. But let's go on with this motion here. We left off at E as a new item, where the prosecutors and Judge Glanville incorrectly advised Copeland that he could be held in civil contempt indefinitely if he failed to testify, all in an attempt to coerce Mr. Copeland to testify. Judge Glanville abandoned any semblance of neutrality and worked in concert with the prosecution by advising Mr. Copeland and Copeland's attorney about legal matters, all to cause Copeland to testify. G. Judge Glanville assisted the prosecution in the preparation of Mr. Copeland as a state's witness, instructing that a list of questions prepared by the state be provided to him. We have a footnote here. As the prosecutors and Judge Glanville have claimed that this transcript captures the entirety of the ex parte communications between the state and Judge Glanville that day, it is entirely unclear how Judge Glanville even had knowledge of the state's list of questions for Mr. Copeland, as the discussion of this is not found earlier in the transcript. Boom! Add this in with what we just watched. An H. A significant amount of Brady material poured out in this meeting, but the same was hidden from defense. Neither the existence of this meeting nor this Brady material was revealed to the defense until the transcript was finally released. The June 7th, 2024 ex parte meeting. On July 30th, 2024, the Honorable Judge Whitaker presided over substantive matters of this case for the first time. The Honorable Judge Whitaker provided much needed clarity to the defense by releasing the rough draft of a transcript of additional ex parte communications between the prosecution and Judge Glanville. This ex parte meeting occurred on June 7th, 2024, and included Love, Hilton, and Judge Glanville. These communications, and the substance thereof, had never been disclosed to the defense until the Honorable Judge Whitaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on the July 10th, 2024 meeting. Instead, Judge Glanville and the state remained silent on this topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implications of June 10th, 2017, as part of her consideration of motions filed to recuse Judge Glanville, upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was, in fact, another ex parte meeting that occurred 3 days prior. This was their secret. So I said earlier in the chat, and you guys caught it too, Judge Krause, in finding that the meeting was pretty much proper, although maybe it should have happened in open court. She wasn't aware of this context when she made that finding. The transcript of the June 7th, 2024 communications is shocking. It also sheds light on how this case has become irretrievably broken. As an initial matter, there is no stated justification for the ex parte communications. The meeting was initiated by the state. Neither Copeland nor his counsel had requested that the state meet in private with Judge Glanville. The meeting itself was illegal. The state, in this meeting, intentionally and wrongly attacked the character of Copeland's attorney, Melnick, claiming that Melnick was not representing Copeland's interests. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interests of our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick, and the footnote says, while the state has maintained, at least at times, they did not realize that Mr. Copeland was represented by attorney Melnick when speaking to him, this excuse is difficult to accept. Their story also has changed. At times, they didn't know. At times, Melnick told them he didn't represent Copeland. At times, Copeland told them that Melnick was not his attorney. At times, Copeland never asked to speak with Melnick. The explanations are all hard to accept. Love has prosecuted Mr. Copeland in case, and he gives the case number, which was resolved on June 29th, 2023. Melnick represented Copeland on this case. Melnick's representation of Copeland is also openly discussed in interviews, which were provided in discovery. Additionally, the fact that Melnick also represented Copeland's interests as a witness in this case was always fully understood by undersigned counsel, as Copeland faces legal exposure in this case. The defense has always acted appropriately and has refused to initiate any conversations with Copeland, who was known to be represented with Melnick without Melnick's knowledge and approval. Melnick's representation of Copeland was no secret. That was a long footnote. If we go back up here, talking about they had productive communications with Copeland outside the presence of Melnick before Melnick had, quote, inserted himself in his client's legal affairs. The prosecutor's claims that Melnick was not representing Copeland's interests is rich, as they were communicating with the person behind Melnick's back. The state had intended to call Mr. Copeland as a witness without granting him any sort of legal protection as a witness. It was only after Melnick inserted, in quotes, himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony doesn't end there. The state, in this meeting, claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client's affairs. At no time, however, did the state ever seek any non-custodial alternatives for Copeland, should Judge Glanville hold him in contempt. And you guys called that all the way out. They were the ones that wanted to put him in jail, but in that entire June 7th transcript, they're acting like, we don't want him to go to jail. Everybody else is the one that's out to get him. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his client, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick had not planned his vacation around Copeland's testimony. This is a ridiculous accusation, as the state intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call his client to testify on June 7th. We have a footnote here that upon information and belief, Melnick had already purchased non-refundable tickets for a trip to Alaska, which was to commence that coming weekend. Perhaps if the state had not cut out Melnick from their communications with his client, he would have been able to schedule his trip accordingly. So, okay. The state was clearly only concerned with Copeland's interests as long as they were directly aligned with their own interests. The state feigned interest in Copeland's well-being to get a foot in the door to Judge Glanville's chambers, all in an attempt to initiate improper ex parte communications. Melnick was not the only attorney who was disparaged by the state and Judge Glanville in the secret June 7th meeting. Love claimed that she was in receipt of an email from Melnick sent to her and Hilton, but also that other individuals had been, quote, blind copied on the communication. The clear insinuation from the conversation is that it was Attorney Steele and undersigned counsel who were blind copied. We get a footnote about these emails. Love goes on to say that her immediate response to this email was to ask Melnick, whose interests are you concerned about, your client's or Mr. Steele's and Mr. Schardt's? Undersigned counsel does not make blind accusations, but neither undersigned counsel nor Attorney Steele were blind copied on any email between Love and Melnick. Later in the ex parte meeting, Love again brings up Attorney Steele and undersigned counsel, noting that we were included on a June 6th, 2024 email from Mr. Melnick, so Thursday. Love and Hilton were also included on this email, in which Melnick expressed his client's decision to exercise his Fifth Amendment rights if called to testify by the state. This footnote here says, undersigned counsel confirms that this email was sent to Hilton, Love, undersigned counsel, and Steele, and asserts there was nothing improper about this email. There's absolutely no requirement that Melnick limit his communications to the state, the very same people who excluded him from communications regarding his client. It is unknown why Love feels that she should have a monopoly on information, or why she feels that defense attorneys should not be included on discussions concerning these matters. Undersigned counsel would like to inquire about these matters with Love, sworn in as a witness, so Schardt wants Love on the stand. Ooh. Do you think Love already read this? And this is why they made the court go live? Judge Glanville abandons any impartiality and echoes Love's thought, asking, quote, why would he, Melnick, have done that? Given, and then before ADA Hilton responds, and that's the state's concern. Love then affirms, that's the point. As Judge Glanville had questions, so do I. Undersigned counsel asks why my inclusion in the simple email communication was of concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this materially false and made-up situation, as if one exists, and tells Judge Glanville that she will contact him when she finds a solution, either over the weekend or on the coming Monday, presumably through additional ex parte communications. And then footnote 12 says, it is unknown to undersigned counsel if the state and Judge Glanville had any further ex parte communications over that weekend, but we are now aware that an additional ex parte meeting occurred on the next Monday, June 10th, 2024. So is there more that took place this weekend? What about the questions we plan to ask? So, where was this footnote? Up here. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to outside agitators affecting the trial, stating, but I see it from just being in the courtroom and tracking. Judge Glanville's concern and inherent skepticism of email communications between Melnick, Attorney Steele, and undersigned counsel exemplifies Judge Glanville's bias and partiality towards the state. The transcripts of both the June 7th and June 10th ex parte meetings show Judge Glanville's clear bias against Attorney Steele and undersigned counsel, and finally provide an explanation, albeit an unacceptable one, for Judge Glanville's treatment of the defendants and their counsel throughout the trial. The illegality of the ex parte meetings now known to the defense, and we have a footnote in this header. The defense is not aware of any additional ex parte meetings that have occurred at this time. That being said, the defense is not all that confident that these are the only 2 illegal ex parte meetings that occurred between the state and Judge Glanville. We now know that 2 ex parte meetings have occurred. These ex parte meetings were clearly illegal and improper. The state relies on King v. State, 2000, in a specious attempt to argue that these ex parte meetings were proper. The state's reliance on King is misplaced for several reasons. First, in King, the state met with the court to provide information that would allow the court to make a judicial determination as to whether the anticipated testimony of the witness was, quote, necessary to the public interest, as is required under law. In this case, Judge Glanville had already conveyed derivative use immunity to Copeland earlier on June 7th, presumably in a third, albeit first time, ex parte meeting. There is no indication that the witness was present for the meeting. In King. So, in King, this is why King is different. There's no indication that the witness was present for the meeting in King. While the actual forthcoming testimony expected of Copeland was openly discussed in Copeland's presence in the Star Chamber June 10th meeting. Second, in King, the defense never alleged that they were not informed of the substance of the ex parte meeting in a timely manner. In our case, purposely hid this information, this illegal and unethical conference, from the defense. So, distinction. The fact that these meetings occurred, much less their substance, was only revealed due to the doggedness of the defense and sheer happenstance. Third, while the subject matter was limited to, quote, the necessary to the public interest requirement of OCGA 24-5 of 507 in King, the subject matter of the June 7th and June 10th ex parte meetings included much more, including specious and knowingly false allegations made against defense counsel and by relations the defendants themselves. These improper ex parte meetings are the result of both grave prosecutorial and judicial misconduct. These meetings were never requested by Copeland, Bumpus, or Melnick. Instead, they were all initiated by the state and welcomed by Judge Glanville. These meetings, when considered with other previously discussed actions of the prosecutors, and Judge Glanville in this case, violated Mr. Stillwell's constitutional rights to due process and a fair trial. These meetings, especially when considered in addition to Judge Glanville's other actions throughout this trial, have also violated Mr. Stillwell's right to a fair trial. There's a bunch of typos in this, guys. He ran out of this court to get this filed, for sure. We saw him run out. In front of an impartial judge. The transcripts of these meetings reveal that Judge Glanville, perhaps based on inaccurate and misleading information provided to him by the prosecutors through ex parte communications, always looked at Attorney Steele and undersigned counsel, as well as our respective clients, with suspicion. Judge Glanville, in meeting with, consulting with, working with, and planning with the prosecutors, clearly abandoned any semblance of impartiality. Both of these meetings occurred during critical stages in this trial. Mr. Stillwell had a constitutional right to be present. So, and here we have Article 1, Section 1, Paragraph 12 of the Georgia Constitution and the corresponding section in the U.S. Constitution. And then Scudder v. State. As Mr. Stillwell nor his counsel were permitted to attend these meetings, Mr. Stillwell's 6th and 14th Amendment rights of the United States Constitution and Georgia Constitution were violated. This is a structural error which will demand reversal, should Mr. Stillwell be wrongly convicted of any counts in this indictment. Remedies. So what do we want? Mr. Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error in this case. Focusing solely on the ex parte communications, The prosecutors and the trial judge teamed up to coerce and intimidate Copeland to change his mind and testify for the state. Copeland's testimony was harmful in itself, but does so much more than that. As a result of this coercion and intimidation, the state has, and plans to continue to impeach Copeland with his prior inconsistent statements, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stillwell and others. These out-of-court statements involve several of the charged events and counts in this indictment, and are central to count 2 of this indictment, which alleges that Mr. Stillwell committed the murder of Donovan Thomas. Guys, this is great going hand in hand with that afternoon jumping back into court we just watched. Mr. Stillwell does not wish to demand a mistrial, absent a finding of goading, and thus jeopardy attaching. So we only want this mistrial if there's no retrial. Mr. Stillwell has been incarcerated throughout the duration of this case. He has been viciously attacked while incarcerated. He almost lost his life. Starting trial all over again is not a viable option for Mr. Stillwell. Despite the persistent legal errors, the illegal actions taken by prosecutors and the previous trial judge, and the damage inflicted by the presentation of Copeland's prior untruthful out-of-court statements, the defense is winning. Additionally, this trial is already tainted by structural errors. Mr. Stillwell does not wish to submit to the desires of the state and Judge Glanville, who have attempted to goad Mr. Stillwell into moving for a mistrial. Mr. Stillwell does not want this case to start all over. Nonetheless, serious errors have tainted this trial. It is unacceptable that Mr. Stillwell must accept that the first several months of this trial have been tainted by prosecutorial and judicial misconduct, illegal ex parte meetings, and a partial judge. It is unacceptable that Copeland's out-of-court statements, which are arguably admissible as a result of the previously discussed illegal ex parte meetings, should continue to guide this case. Judge Glanville's hostility towards, and suspicion of undersigned counsel, has likely created a lasting impression on the jury, who surely view a trial judge as a person of authority. Carrying on with this trial as if nothing improper has occurred is not an acceptable option. The structural errors and other legal reversible errors in this case must be considered in the context of how they occurred. All of these errors have been caused by the prosecution and Judge Glanville. Neither Mr. Stillwell, undersigned counsel, nor any co-defendants or their counsel have caused or invited any of these issues. Hilton is a seasoned prosecutor of nearly 15 years who holds the title of Deputy District Attorney in the Fulton County DA's office. Per the District Attorney's website, she helps lead the Special Victims Division. She has received many awards with the District Attorney's Office and also has taught trial technique classes at Emory University School of Law. Love is an attorney with almost 20 years of litigation experience, almost exclusively as a prosecutor. Attorney Love is a Chief Deputy District Attorney of the high-profile cases and difficult witnesses division within the Fulton County DA's office, and is part of that office's executive team. She leads a division in the largest district attorney's office in the state, one that is dedicated to cases involving difficult witnesses. The Georgia Court of Appeals has noted that state prosecutors are generally knowledgeable and well-trained, too knowledgeable and well-trained not to know the consequences of basic rules of prosecutorial procedure and conduct. That's Wilson v. State. Prosecutors, as recognized and experienced as Hilton and Love, should certainly be held to this minimal bar, if not much higher. Surely Hilton and Love, with their knowledge and experience, knew the impropriety of these ex parte communications. Their experience told them something else, however. Based on their knowledge of the law of impeachment and prior inconsistent statements, the prosecutors knew that if Copeland did not testify and remained in jail, even a partial judge would be hard-pressed to allow the jurors to hear the multiple hours of Copeland's recorded statements. Here's the why. The ex parte meeting was a calculated risk for the prosecutors. Either Copeland would be intimidated and coerced into testifying, or the illegal ex parte communications would be grounds for a mistrial, and the state would have time to regroup and begin anew. So, they have a win-win, if you think about it, for the state. So, the risk is worth it. Judge Glanville currently serves as the chief judge in Fulton County Superior Court. Per the Fulton County Superior Court website, he has been a lawyer for 37 years and has served as a judge for 29 years, 19 of which as a Superior Court judge in Fulton County. Judge Glanville knows the rules concerning ex parte communications, both in the Uniform Rules of Superior Court of Georgia and the Georgia Code of Judicial Conduct. Based on the experiences of prosecutors Hilton and Love, as well as the experience of Judge Glanville, the notion that the decisions to hold these repeated, secret, illegal, and unethical ex parte meetings were due to inexperience or simple lapse in judgment does not pass any test. He used the language, you guys. Doesn't pass any test. These were conscious decisions. Shout out to yesterday's court moment with Caleb Bumpus with the stare down of prosecutors Love and Hilton. These were conscious decisions to secretly violate the most basic of Mr. Stillwell's constitutional rights. Several factors in this case, including the prosecutor's and trial judge's wealth of experience, the egregiousness of the prosecutorial and judicial misconduct, the facts that the evidence presented so far have been far from overwhelming, the structural and reversible error already baked into this case, and the repeated violations of these rules all clearly support a finding that their actions were intentional and designed to go to mistrial. So we have State v. Jackson, Anderson v. State, and Wilson v. State. Conclusion. This case is constitutionally and legally broken at this time. Mr. Stillwell is not requesting a mistrial absent a finding of goading, but appropriate remedies must exist. Possible remedies include, but are not limited to, disqualification of the prosecutors involved in this misconduct, as Glanville's already been recused, the dismissal of this indictment with prejudice, instructions to the sitting jury that explaining the situation in full candor and or a mistrial, with the finding that a mistrial caused by judicial and prosecutorial misconduct, and the defense was goaded into any such request. Wait, judge is back. Don't do that. I'll flip back over. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stillwell's arguments and issue an order which will fully and adequately protect Mr. Stillwell's constitutional rights. Respectfully submitted, Max Schardt, in the middle of the court day, running out of there to submit this document. What do you think, you guys? I mean, this is some heat, some energy if we're considering what we just heard on that part 2 of today's court hearing. This is a lot of stuff. And don't make me double check. Do we really have the court back? But yeah. So, we have Brian Steele saying Kenneth Copeland did in fact say in the Star Chambers meeting at some point that he killed Nutt on June 10th. We also have Melnick saying that Love is a liar. And we have Max Schardt. This new, well, was it a renewed motion? Yeah, his renewed motion for a fair and constitutional trial and appropriate remedies. Laying it all out.